Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg in partnership with justiceinfo.net.
Hi, Steph.
Hi, Janet.
So this is the last in the series that we've been doing for the last few months about universal jurisdiction.
I'm sure that you have something in mind when we start again in September, right?
Oh, yes. Of course, we've hardly scratched the surface on Europe, and we have so many more places to do in Latin America. And of course, we have our own beloved Netherlands to do. And I think there's plenty to say on that, and we'll keep that right from the end. Yeah, this is the last one for the moment.
And what's on our agenda for this month?
Well, after last month looking at universal jurisdiction directly from the Rwandan perspective, we're staying in Africa, and this time we're heading to Kenya.
And we've talked about Kenya before on the pod, but so much of what we discussed was related to post-election violence in the first half of the 2000s. I remember one of our first podcasts was sexual violence survivors working on reparations and children born of rape, and we'll link to that in the show notes.
Yeah, we've done a couple of episodes on that, so we got different things to link to. In that first lot of post-election violence in the late 2000s, reparations have finally been agreed for a small number of people, so we will plan to look at the issue of reparations.
We also looked at the alleged crimes against humanity perpetuated by Kenya police in another presidential election in 2017, and we looked at the first ever application of the 2008 International Crimes Act in what was known as the Baby Pendo case, where police are alleged to have killed a 6-month-old baby, Samantha Pendo, who was at home and in the arms of her mother at the time.
Yeah, we're going to hear a lot about this International Crimes Act because that's at the heart of today's podcast. Now, though, we have the first ever, under that act, potential war crimes case. And the war concerned is not in Kenya, which, as you know, is not at war, but next door neighbour Sudan is. And victim applicants from Sudan and the accused are Sudanese. So it's slap bang universal jurisdiction.
And who is behind the effort of bringing this beside the victims and the accused, obviously? But we know there's always these organizations that help these cases come to the court.
Yeah, the people with the strategic idea to do this are Legal Action Worldwide, Antonia Mulvey. And as she told me, there are 10 Sudanese victims. I'll let her explain what she can about it. Then maybe you and I, Steph, can have a chat later about kind of the broader picture of potential avenues for accountability for everything going on in Sudan. But after Antonia, we also hear from Owiso, who's an international lawyer based in Kenya, and he is counsel in this attempt at a case on war crimes under the International Crimes Act. And as you'll hear, he's also involved in the Baby Pendo case. And he speaks about the realities of kind of how you push this boulder up the hill of the Kenyan justice system. So first, here's Antonia.
There are 10 brave Sudanese men and women that filed the complaint. They were in and around Khartoum when the crimes happened. And I must say it took real courage to file this. And one of the women that we represent told me, I'm filing this complaint because I don't want what happened to me to happen to any other women. Now, we've protected their identity. There are very serious risks of retaliation to them. Their identity will remain protected. So I can't tell you where they are, but we've taken the security risks very seriously.
I mean, I will press on that, not on the security risk, but if you can't say where they are, what is the connection with Kenya?
The connection with Kenya is in relation to the persons of interest. So we've identified 10 persons of interest, all from the Rapid Support Forces who are mid to senior commanders. And a number of them have ties to Kenya. They move freely in and out of Kenya. They have reported citizenship as well as other ties, including financial ties. And we've seen in the Kenyan media that there's been a lot of public outrage to the fact that these war criminals are moving freely in and out of the country. So that is the direct link. And Kenya has the legal framework under the 2008 International Crimes Act to allow for investigation and prosecution for war crimes and crimes against humanity. And there's some other points here as well. Kenya is the neighboring country, and Sudanese have fled the war, which, as we know, has been ongoing for years, and are in Kenya as well. So we've got multiple reasons that tie Kenya to this complaint and to the crimes that are taking place. And also we see time and time again African solutions for African problems. And we want to bring these cases nearer to where the crimes are taking place, nearer to where the victims and the survivors are, and importantly, where the perpetrators are.
What kinds of crimes are we talking about? Because I know that Legal Action Worldwide you've done your reports particularly on conflict-related sexual violence, but the most recent ones I read were more to do with al-Fasher, which we've podcasted about before, yet you say these are crimes in Khartoum. So what kinds of crimes are we talking about? Are we talking about direct perpetration? And if not, is it linkage evidence? Well, I don't know how much you're allowed to tell me.
Mm-hmm. We're talking about war crimes and crimes against humanity that took place in and around detention facilities in and around Khartoum. So Sober Prison, Riyadh Complex, and other informal detention sites. Murder, imprisonment, sexual violence, rape, sexual slavery. They witnessed their family members being killed, torture, persecution. The complaint does not look at genocide because this complaint is not related to the crimes that are taking place in Darfur and are continuing actually in Darfur. And yes, so a number of those that we represent, men and women, were subjected to horrific sexual violence when they were being detained. Now, the allegations are both against, as I mentioned, senior and mid-level RSF commanders who both have directly perpetrated the crimes, but also those in command responsibility. But I can't tell you more than that.
But you've also done reporting on and suggested that there should be some accountability, some action to do with the RSF and the funding of the RSF, particularly from foreign sources, because we know that this war is being continued and perpetrated because the weapons are flowing in, because other countries are being involved. So how far up the chain are you going, or would you be prepared to go?
Look, let's put it this way. The RSF for years have been committing horrific crimes. But as we know, and the report that we brought out looked at the flow of arms and the transfer of arms to the RSF, and primarily from the United Arab Emirates. So we're looking at multiple aspects. We want to send the message that there's going to be no safe haven for criminals and for those who are supporting them. So we have also filed a complaint with the International Criminal Court on behalf of Sudanese women who suffered from horrific sexual violence in Darfur. And we will continue to support the ICC in their investigations in that matter. And also the report that we brought out looks at the flow of and transfer of arms. We need to halt the transfer of these arms, which have facilitated the crimes and have facilitated the sexual violence that took place in Darfur. And in particular, we focused on al-Fasher and said that individual RSF commanders have also committed the crime of genocide.
So you've got the ICC and now you've got this application in Kenya. Where else are you looking to try to get some forms of accountability? Or is that all a little bit secret still at the moment?
That is a little bit secret, Janet, but let's put it this way. We haven't stopped. More cases will be coming. We know that multiple actors have committed crimes in Sudan. We're led by the evidence, and we're led by what the victims and survivors, what the communities are asking for. They're asking for justice and accountability. We want to be able to deliver that. We want to send a message that these crimes are being watched, where people travel is being watched. So we will continue. So more is to come.
As you heard from Antonia, it's limited what she can say about it, and I kind of pushed the door a little bit on Al Fasher, which is in Darfur, not in Khartoum, and I pushed a bit on United Arab Emirates involvement. But again, I suggest we park that for the end of the pod, Steph, when we discuss avenues to accountability. Can I just give you the warning? We're going to require some Stephopedia.
I have just yesterday spoken to somebody about the ICC in Sudan, so I hope I'm up to snuff for Stephopedia on this.
Excellent. Thumbs up from my side. So let's focus instead again on the International Crimes Act, the ICA. And so I asked Owiso, he's the Kenyan lawyer involved, how is it that Kenya actually has an International Crimes Act? Because not everywhere has. And he explained to me, of course, Kenya was one of those countries that signed up to the Rome Statute, the International Criminal Court, joined the court. But this act was in fact part of the kind of domestic solution that they came up with at the end of the 2000s to try to help to stop and deal with the post-election violence in 2007, 2008. And because this pod is actually about UJ, I do kind of push a little bit on the sort of legalese and the technical side and explore how it is that Kenya can be a venue for Sudanese victims' war crimes prosecution where there are no Kenyan victims involved. So here's Owiso explaining how Kenya got an International Crimes Act.
It was not necessarily because of the ICC. The context of it is, Kenya was in no rush to domesticate the Rome Statute. We had ratified it and said, the country said, okay, we've done our bit, that's it, we are moving on. But 2007 happened and we had post-election violence. And as part of the negotiation process, the accountability bit of it was that, yes, you have to, as a country, you have to have a domestic system or mechanism for prosecuting the crimes against humanity that occurred in 2007. That's December 2007 and January 2008.
So it became part of that.
Yeah.
I remember the huge debate in Kenya at that time. Are we doing enough locally to avoid essentially a prosecution in The Hague?
Yeah, so actually the Hague was not the first conversation. The first conversation was we have to do this domestically. So that was, in fact, part of the, I don't want to call it a peace agreement, but the sort of agreement that ended the violence was that there would be a domestic process of accountability. So the ICC was sort of something at the back of the whole conversation. If the domestic system or process doesn't kick off, then the ICC comes in. So in order to have a domestic process going, we needed to have a legislative framework. And because we had already ratified the Rome Statute, it was just easier to domesticate that, come up with an International Crimes Act that both domesticates the Rome Statute, but also provides sort of a legal basis for Kenya to prosecute international crimes domestically, wherever, regardless of where they're committed. And I would imagine, or I would like to say that because of the context of the ratification or the enactment of that particular legislation, I don't quite suppose that Kenya was very concerned about crimes happening elsewhere. That was not necessarily the concern. The concern was, okay, stuff has happened here, we need to deal with it here. So I think that is why it was slightly easier for that legislation to include a provision that Kenya would have jurisdiction regardless of where these crimes are committed. I don't think our legislators thought about that particular provision, because if they had, I suppose the debate would have been a bit more difficult.
Just say we did one podcast on the application on crimes against humanity in relation to police, Kenyan police, the investigations that were going on there, some terrible cases. So I was kind of aware that it domestically. So what about this international parts to it? Not only international crimes, but international application. Has Kenya ever gone down this road before?
No, actually. In fact, the entire act itself, even domestically, it's not exactly been successfully applied. The first time it was applied domestically was with respect to protests that happened in 2017 following elections, and where the police committed certain crimes, sexual violence. They murdered a couple of people, including the so-called baby Pendo, a 6-month-old child. That process has taken a long time. The trial is just kicking off somehow. So that is actually the first time the International Crimes Act is being tested domestically with respect to domestic crimes. But with respect to crimes committed elsewhere outside Kenya's territorial boundaries, it's never been done before.
Whoa.
Yes, the Act provides that it's possible to do it, but we have not tested it. So this would be the first time that, if this goes through, this would be the first time that's being tested.
Okay, well, in the Kenyan system, which I imagine is at least partly derived from some of the British system, as far as I remember, everybody wears horsehair wigs in your place. What are the kind of things that we need to understand? Because we spent quite some time looking at some of these very other jurisdictions, France, Argentina, where you have this whole role of victims and ways that people can apply and what roles they can play and who gets to appeal stuff and so on. How does it work in Kenya? Who starts and who decides?
Well, thankfully, we don't wear wigs around here anymore. It's a common law jurisdiction, yes, but we didn't borrow literally everything. We discarded the wig part, thankfully. But it's generally a common law system with the usual common law procedural aspects of criminal law and all that. But this being an international criminal justice process, even most common law systems, even the UK, where we borrowed most of these things from, at the time that these things were borrowed in the 60s, the UK was not even developed. So this is sort of new to everyone, right? So while it has procedural aspects of common law, it's a bit diluted in the sense that we are developing this as we go. And we are, of course, adopting the international sort of procedural aspects of international criminal justice. And this has also been made easier because in 2010, Kenya came up with a new constitution, which overhauled the entire constitutional framework that was inherited from the colonial system. And that new constitutional framework, the 2010 constitutional framework, sort of expands the scope, the locus standi scope, in terms of vindicating rights. So it first, of course, direct victims have a right to approach courts. Those who are directly affected, regardless of where you are, in the context of the International Crimes Act, if you're invoking the International Crimes Act, you do not have to be a Kenyan to approach the Kenyan courts with this. But at the same time, because of recognizing that sometimes victims may not necessarily be in a position to represent themselves, anybody else representing victims can also invoke this process. But then there's also a third layer to it. Anyone else who is, you don't have to even be related to the victims. As long as that particular issue is of public interest, you can also invoke the system. So either direct victims, persons representing victims directly, or anybody else acting in the public interest.
How did it work in this case? How have you tried to test those boundaries?
Right. So this is still the very beginning of the process. It's still very early days in the process, but this is how we anticipate it will unfold, especially considering the procedural process. So the first thing you do is you approach the Director of Public Prosecution, that is the DPP, with a complaint, because they have, operational independence. They have the right or the authority to make that decision whether or not to prosecute. So the DPP can do one or two things. Okay, one of three things. If the DPP looks at your complaint and determines, well, there is enough here for me to commence a prosecution, they can do that. They will straight up lodge, file charges at the High Court. Or secondly, if they determine there is something here, but I don't have the evidence yet, they can then direct the Inspector General of Police to conduct an investigation. That's the second thing they can do. The third thing the DPP can do is to simply say, well, I have looked at your complaint and there's nothing here. I am not going to prosecute. So either the DPP can say that expressly and write to you and say, we've looked at what you've sent us. There's nothing here. We're not going to prosecute. Or they can constructively do that simply by keeping quiet.
So if whatever decision they make, what rights do you have after that? Can you then go to court and say, oi, you've got to reverse that decision or whatever?
Yes. So if the DPP determines that there's enough to file charges, they file charges, but the victims then also have a right to be represented in the system. We have a robust, it's relatively new, but a robust victim participation framework where victims can directly appear in court through, directly either by themselves or through counsel. So they will not be prosecuting the matter if the DPP takes it up, but they will be represented. They will have all the rights that victims have, for example, at the ICC, cross-examine witnesses and present evidence and all that. But in the event that the DPP refuses to prosecute, then the victims, either themselves directly or through their counsel, can approach the High Court to ask the High Court one of two things. Either for the High Court to compel the DPP to re-examine that decision. Of course, the High Court can't direct the DPP to prosecute, but the best the High Court can do at that stage is to say, well, either you did give reasons or there's no rational decision made here, so please re-examine that. But the second thing the High Court can do, which the victims can also ask directly in that application to the High Court, is, okay, the DPP has determined, according to the DPP, they cannot prosecute. But according to us, there is enough evidence for a prosecution to be launched. So please give us authority or permission to launch private prosecution, which can happen. So you can't, as victims, you can't directly do that after, once the DPP refuses to prosecute, but you have the right to go to the High Court and ask the High Court that, hey, we asked the DPP to launch prosecutions with respect to international crimes committed here and there. The DPP refused to do so, but we believe that there's enough evidence for us to do this ourselves. So if the High Court then gives you permission, you can then launch your own private prosecution. And in that case, the victims will be acting as prosecutors. Of course, if that happens, the DPP still has sort of a right to still come in at any point of the process and take it over and prosecute it, but of course not to take it over and terminate it. That's a different story. But the DPP can still come in and take it over and prosecute it. But if the DPP doesn't do that once you have permission from the High Court, then you can launch private prosecution by yourself. This private prosecution is relatively common in this jurisdiction, but with respect only to what I would call ordinary domestic crimes. We've not tried it before for international crimes, except I mentioned earlier there's the so-called Baby Pendo case where, involving police officers and all that. So what the DPP did in that respect is, first, the DPP filed charges against about 12 police officers. Then at some point down the line, the DPP then withdrew charges against most of them and left only 4. So what we have then done, because I'm also counsel in that case, what we have then done a few months ago or 3 months ago is we have gone to the High Court, asking the High Court either to compel the DPP to review that decision and bring back those names onto the charge sheet, or to allow us to prosecute them by ourselves. It's also the first time it's being tested in an international crimes context, and in the context of this filing with regard to RSF, if the DPP does not make a favorable decision, then of course the victims would still have a right to go to the High Court and ask for that specific permission to launch private prosecutions. It's a long road, but yeah, just the beginning.
And I was just wondering whether Kenya particularly positions itself as, it's a UN city and it sometimes gets involved in things like peace talks. And I imagine in relation to Sudan that Kenya might be involved in some kind of negotiations between the government of Sudan and the RSF. We have a decision that you will have come across at the ICC from judges saying that arrest warrants could be suspended because of peace talks. And we think that that's in relation to Ukraine, and we think that's in relation to potential talks in Geneva, and because there's an arrest warrant against the Russian president and some others that could affect them. I'm just wondering, how do you see that political aspect playing out in Kenya?
Well, I believe there are two things to it. I mean, there are two things I can say with respect to that. In the early days, the Kenyan government was quite involved in, or at least attempted to be involved in the peace process from what would have appeared to be a neutral position. But that facade quickly fell off. And where we are at the moment is that while the Kenyan government would pretend to be quite concerned about the peace process in Sudan, it is in the public domain that the current administration is actually very supportive of the RSF, politically and in terms of business. They do business together and all that. But politically, in the sense that not so long ago, the Kenyan government hosted RSF in Nairobi in the attempt to form a parallel government. And because of that process, the Sudanese government, I believe, actually withdrew their ambassador. So there's a lot of bad blood between the Kenyan government at the moment and the government in Sudan, that is the al-Burhan government. So Kenya is not considered as a neutral party in any peace process. Of course, the Intergovernmental Authority on Development, that is IGAD, of which Kenya is a very important member, is at the forefront of peace negotiations in Sudan. But I would not say that Kenya is playing any direct and significant role in that process. In any case, actually quite the contrary, Kenya is viewed in that context as having taken sides. So the political backlash I would anticipate is not with respect to the peace process itself.
No, I've got it wrong entirely, haven't I? I mean, it's going to be in respect to the Kenyan authorities saying, "Get off! We don't want you to touch our RSF business partners."
Exactly. So that's why I said with respect to the political backlash we anticipate is not with respect to the peace process, but it's with respect to the Kenyan government trying to protect its allies, because they've been adversely mentioned, and I would imagine that in that complaint, the persons that the DPP would be looking at, the persons and even the entity itself, it implicates quite a number of senior government officials in the current regime. So that is the political angle that I see, not with respect to the peace process. Because with respect to the peace process, Kenya, whatever claims the Kenyan government could make, it's not playing any significant role in that peace process. It's actually considered. I would venture to say that the Kenyan government is considered as part of the RSF when it comes to those peace negotiations. So it's a whole different ballgame.
So how independent is the DPP from the government itself? Will there be political pressure on him or her?
Well, I'll say two things. Legally speaking, the DPP is very independent because the office of the DPP is a constitutional office that is not answerable to the executive or to anyone. It's independent. That is the legal position. So the DPP can make or should make decisions without being instructed by anyone. But the reality of it is that the executive plays quite a significant role, especially with respect to certain cases that are sensitive to the executive or to members of the executive. So, of course, at this point, we are treating the DPP, we are giving the DPP a lot of grace and the benefit of the doubt. And we hope that the DPP will pleasantly surprise us. Because at this particular point, the best we can do is act in good faith. The reality of it is quite different, but we do expect, because it's been about 20 days since we filed the complaint, so we do expect a decision in the next maybe 10 or so days. If not, then of course we will have to prompt the fellow. So we'll wait and see. We can take this up again after that. It's a long one. It's got to take a while. So this is just the beginning. I probably believe in the next 3 or 4 years, we'll still be talking about the same thing. It's a long road.
I'm just going to add here a quick update. Owiso said that they were waiting to hear the results and those still haven't come in. So here's the Stephopedia charts. So I mentioned El Fasher, which is very far from where we're speaking about Khartoum, and it's over in Darfur, right over in the west of Sudan. That's where horrendous crimes were alleged. I think it was last year to 2025, but I'm sure you'll correct me, Steph, as we come to that, when the Rapid Support Forces, the RSF, managed to actually take it over. We've had reports and a half from everybody, including the UN, doing work on that. So, Steph, let's take it. What can we actually say about this bigger picture of the war? What kind of accountability efforts are we seeing in relation to Sudan?
Well, we are notably in our world very big seeing the ICC is looking into Darfur, not the whole of Sudan, but Darfur particularly comes under ICC jurisdiction because the UN Security Council, way back in 2005, when we had the first kind of accusations of genocide against African tribes in Darfur, the situation in Darfur was referred to the International Criminal Court. And they have, from that period over only...
Like 20 years, Steph.
20 years.
They've been going at it for 20 years. They've had how many trials? Just remind me.
They have had one trial, which is just finished, and they have outstanding arrest warrants, and the only arrest warrants, public arrest warrants that we know of for accusations of genocide against the Sudanese now ex-president Omar al-Bashir. I know that the ICC is still very involved in looking at what is going on currently in Darfur, and especially about El Fasher and Al Janeina. They have issued repeated warnings that what is happening there and the crimes that are alleged do fall under the jurisdiction, and they are looking at it very closely. Reuters did a big story or a video report, I think, on El Fasher just a couple of weeks ago. We'll link to that in the show notes, where they basically charted the takeover of the city by the rapid support forces and kind of the massacres that are alleged to have happened afterwards and linking them to certain people. And when that was put out, I got some interested phone calls and approaches by people at the ICC saying, we're going through this with a fine-tooth comb to see.
We need your evidence. Give us your evidence, guys.
Which is, it's one of those things that news agencies don't really do that. You can take what we have on the web, but at the moment that journalists get perceived as providing direct evidence for war crimes courts, it makes it dangerous for our colleagues. So.
What about the bigger geopolitical side of things? Because that's also what I mentioned with Antonia, and I have seen a lot of reporting around that. What is alleged is that the United Arab Emirates has been very heavily involved. I believe it's no longer kind of a secret because it seems like everybody and their mother is writing reports on this. They've been supplying the RSF, but then we've also got other countries working with the Sudanese government, and there's a big movement, as far as I can see, to talk about what it means in terms of potential accountability avenues on arms supplies. I don't know exactly what that would mean, but there are at least one court, maybe two courts, maybe just one court. You say, Steph, that may be involved in The Hague.
What we saw last year is that Sudan itself brought a case against United Arab Emirates for violating the Genocide Convention, for allegedly supplying RSF troops with weapons.
That was at the International Court of Justice, but it didn't quite work.
No, the problem there is that Sudan asked for provisional measures, the kind of emergency thing, please stop doing what you're doing while we look at this case. But the United Arab Emirates has a reservation to the Genocide Convention, which essentially means that you cannot take it to the ICJ for violations. So we had those hearings, and Sudan got a public forum to say what it accuses the United Arab Emirates for. But then in the end, the judges said, sorry, they didn't sign the right bits of the convention, and so we're going to chuck this case and scrap it from
Jurisdiction.
Yeah.
I was speaking to an international lawyer about another case earlier this week, and he said that you will carry on seeing people knocking at this door, whichever countries are involved, because of this sense that how can any country have a reservation on genocide? You just can't. So people will carry on arguing that, but the judges so far aren't convinced. But I also had seen kind of passed through my email, and I decided to pass it on to our great colleague Margherita Capacci. She is covering this now. An Article 15 application set of documentation at the International Criminal Court. Do you want to just run through the outline of what we know there?
Yeah, so this is, as we know, Article 15 communications. The court gets tons and tons of them, but when they're really, really good and put together by able lawyers, it's sometimes interesting. And so what I do when I get these Article 15 communications is I try to check if it could potentially go anywhere. So again, when I spoke to one ICC contact, they seemed quite interested to know what would be in this Article 15 communication and also the link to other states. So maybe that's just their special interest. On the other hand, it leads me to believe that maybe somebody will take a closer look at this at the prosecutor's office. So what happened with this Article 15 communication is this group of lawyers and NGOs urged prosecutors to investigate criminal responsibility of foreign actors under the Articles of the Rome Statute, which makes it possible to prosecute those who aid and abet or knowingly contributed to crimes committed by a group acting with a common purpose, as it's called.
Again, these submissions, I agree, sometimes they're more interesting. Sometimes they feel to me a little bit like spaghetti. And my reference there is, the traditional idea of throwing spaghetti at the wall, that you just see what will stick. But we have seen in different cases, completely different other cases, the spaghetti does stick, that somehow you get jurisdiction. And this particular one also names a really wide range, apart from the United Arab Emirates. Also, I caught up with it and it said Libya, Ethiopia, Chad, Somalia, Kenya and Uganda. Kenya, there we go again. But also on the other side, ideas of who's funding the Sudanese side, who are also accused of various atrocities, and that's Iran, Turkey, Egypt. What do you think about spaghetti stuff?
I think sometimes, as you say, if you have a bright idea, it kind of sticks. I think this is another attempt to throw everything at the wall. What we've seen in reporting is a lot of accusations of United Arab Emirates involvement. I wonder, I know that the ICC, as always, it's overstretched and cash-strapped and
under political pressure as well. I mean, we've got sanctions on it, and suddenly they're meant to take on yet another sort of big country. I mean, they have taken on Russia and they have taken on Israel. So maybe they're up for taking on yet another non-member state and saying, we don't need your support. We'll just, without, what was it Bensouda used to call it? Without fear or favour.
Without fear or favour. I mean, they could do that. I think looking at the reality of that that we know of applications or arrest warrants yet for current events in Darfur, where there are people who have been identified as potential perpetrators. I think that it's maybe a leap to think that they will go for this complicated, potentially also politically fraught idea to target this other big country. But, as we've said in earlier pods, the rules around arrest warrants and applying for arrest warrants have changed, and the Office of the Prosecutor can no longer decide to make them public. They are secret by default, and only a judge can make them public. And the same with if an arrest warrant is issued. It used to be public by default, and then you had to make it secret, and now it's secret by default, and a judge has to make, or a panel of judges has to make the decision to make it public. So I think with the pushback they've gotten on their public arrest warrants, maybe now the court is kind of keeping everything under wraps. And so it's really hard to say what's going on. But I feel that if they haven't done the more recent Darfur cases on kind of local perpetrator level, would they immediately level up to involvement of a foreign actor? I mean, that's hard, right? You would think if you look at how you build cases, you start with kind of crime base and the atrocities and somebody who's responsible. And when you have that person, you can maybe link them to receiving arms from abroad. So in kind of technical building a case.
Yeah, but I mean, let's look at what the court has done in the last couple of years. That's not building a case, that's going straight for the top in a lot of times. So I can see it, but I agree with you. I can also not see it. So one to watch. See you for last week, which will be our last week's podcast in a couple of weeks' time, and then we'll be taking a break in August. So speak to you again soon.
Thank you. Bye-bye.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.